Respectfully stated, each of you swore an oath to uphold the Constitution. And if you don't understand the provisions that you swore to uphold, then you're not fit for office. Hey, Tennessee, those of you who know about my work, I need you to step up and support me. You know that my work transcends party politics and is as profoundly important as the work of the founders when they declared independence. For those of you who don't know about my work, the continuance of our American way of life, you need to take a look at my work and understand what I'm trying to do. I'm fighting to restore our proper form of government. I'm fighting to restore the voice and power inherent in we the people. I'm fighting to end corruption, and I'm fighting to restore the Tennessee Constitution to its correct language. I'm going to put down in the first comment, I'm going to put a link to a presentation that I made to the Sumner County Republican Assembly. I'm an independent candidate, but the leaders of the Republican Party recognize the profound importance of my work, and they invited me to speak to a group of Republican citizens there. Take a look at that video and you will understand how profoundly important my work is, and that every citizen needs to learn and understand what my work is about. I'm doing my part. I'm spending thousands of dollars fighting in our courts and in our legislative houses. I use all of my vacation time to do research and to go down to the General Assembly and testify down there about these unlawful alterations of our form of government. I spent hundreds of hours writing legal briefs, and there's no benefit to me. There's no personal gain. I'm fighting to restore the voice of the people and our proper form of government. Last election, even as an independent candidate, I was a one-man campaign. I picked up 51% of the vote in Davidson County, changed an hour later to 47%. Maybe there were some mail-in ballots for my opponent, I don't know. And I picked up 27% of the vote overall in my Senate race in District 18. That's incredible performance. And that was from the people understanding my work and sharing that with their fellow citizens. Now, I'm asking you to do your part and help me reach more Tennesseans, and I'm asking you to make a $5 to a $25 monthly recurring campaign contribution. Surely everybody can afford $5 a month. And considering the work that I'm doing, it's the best investment that you can make in this country and in your children. I'm going to put down a link to my website in another comment, and on the home page at the bottom of that is a secure PayPal link. All the contributions I use to reach more citizens, and I'm extremely cost effective in how I do that. I don't hire consultants or anybody to do my advertising for me. I do my own video work. I get help with graphics, but other than that, I do everything on my own. And we picked up, such a large share in the last election. If I can get help with $5 to $25 a month from several of you, I can use that, and I can reach every Tennessean. I typically pay maybe 2 cents to 6 cents per engagement on social media advertising. It's extremely cost effective. In last election, I was reaching 1.2 million Tennesseans. I'm going to switch over to my desktop, and I'll show you how easy it is to make that campaign contribution. I'm also going to include some clips of testimonies and arguments that I've made in our courts and legislative houses. So thank you for taking this time with me. Any support that you can give to this is greatly appreciated. My name is John Gentry. I'm a candidate for governor 2022, independent candidate and a constitutional Republican. God bless, Godspeed to us all, and in God we trust. Switch over to my desktop. I just want to give you show you real quick how easy this is. My website, you may need to type in this https://. Google doesn't seem to like me on my website too much. It's https, it's a secure website, but it's We the People, V as in Victor, 50.com. So that's my website. When you go here, this is the landing page that you'll hit on. And you just scroll down to the bottom of the page, and here is a secure PayPal link. And it actually takes you to the PayPal website. And while that's loading up, so make your contribution here, $5 a month, make this a monthly donation, and then select donate with a debit or credit card, unless you want to pay through PayPal, but donate with a debit or credit card here. It's going to ask you if you have a PayPal account. You can do one time if you prefer, and then click continue, and then you put in your card information and billing address and everything, and then donate. You click the agree here and donate. It's that simple. Takes just a few minutes. This would help me so much to reach thousands of other Tennesseans with my work. So thank you. And I've got some clips coming up here, some of the work, give you guys an idea how hard I'm fighting for you guys. As members, you have inherited some incredible mistakes from your predecessors. Mistakes that have unlawfully altered our form of government and that cause great harm to the citizens of the state. Our first step must be to correct the Tennessee Constitution on these houses' website held out to the people. I hereby instruct you to correct the false version of the Tennessee Constitution. Your continued refusal to do so is treason to the Constitution, and it's violation of your oaths of office. The last phrase of Article 1, Section 23, I have viewed the original 1870 and 1834 Constitution with my own eyes in the archives. The last phrase says by address or a remonstrance, or remonstrance. We have a choice. And that language has been altered in the PDF version held out on the Secretary of State and the General Assembly websites. Our government was founded on checks and balances and separation of powers. And there is no check of the judiciary, none whatsoever.
Absolutely.
What is a judge? A judge is an attorney in a black robe. And attorneys are one of the least trusted professions in this nation, just above car salesmen and members of General Assembly and members of the Congress. So we're going to slap a black robe on them and call them Your Honor, and we're going to trust these guys, right? How stupid are we? In 1822, Governor Carroll, our third governor for Tennessee, he said a well-regulated independent judiciary is so essential to the character of a state that it has a strong claim on your attention at all times. That was to the General Assembly, our third governor, because they had huge problems in the judiciary even back then. This matter before the body is to approve the rules for the Tennessee Board of Judicial Conduct. The fact of these constitutionally repugnant rules that I will lay bare momentarily are prima facie evidence that this agency's intent is to conceal and protect judicial misconduct and criminal conduct, and why our founders prohibited second offices of trust to prevent corruption.
Chairman Sanderson, you recognize, sir.
Thank you, Mr. Chairman. Mr. Gentry, you heard the testimony or the presentation from the sponsor of the bill, and he contends that this is a bill that we need, and you contend it's not a bill that we need. That puts us in conflict. And so how do we disseminate between what you say and what he says?
You recognize Mr. Gentry.
Well, thank you for asking that, Representative Sanderson. The next point I was going to make is the rules of professional conduct require a lawyer who knows that another lawyer has engaged in misconduct shall report them to the Board of Professional Responsibility. And the same is in Rule 10, Code of Judicial Conduct. A judge that knows of attorney misconduct shall report them to the appropriate authority. So here we have a complete breakdown. We've got an attorney filing a frivolous lawsuit. We've got opposing counsel who is failing to report them for ethical violations, as well as the judge. The whole thing has broken down. If we want to solve frivolous lawsuits, it's not through a slap bill like this. I would encourage, and I would be honored to assist in drafting a bill to properly address this problem. And to do that would be to fine and sanction the attorneys from both sides and the judge who are involved in a frivolous lawsuit. that don't report that misconduct to the Judicial Oversight Agency or to the Board of Professional Responsibility. So that's the conflict, is we need to start enforcing the ethical rules and start to heal our nation of the misconduct that's happening in our courts. This agency, the testimony that you just heard from the Board of Judicial Conduct, they are impotent. And they just said that they are impotent. When they said, oh, well, if the judge just resigns, there's nothing we can do. They are impotent. They can do nothing to provide judicial oversight or judicial accountability based on their own testimony. They should be abolished. Bless you for that question, sir. We have to restore the right of remonstrance. In the 1800s, they had a Grievances and Propositions Committee. We need to let the people know that when they complain against a judge, they do it through remonstrance to their representative. And as I discussed before, that remonstrance would be reviewed in the judiciary. And we need to start impeaching judges and send a clear message. Tennessee is the volunteer state. And let Tennessee lead the way, because this corruption of our judiciary is not a Tennessee problem. It is a problem across this country and across this world. And I implore the members to have the courage to abolish this agency and let Tennessee lead the way, that the judiciary has been proven incapable of self-government and self-oversight, and that the legislative houses are going to take back the power of impeachment. And under Article 6, Section 6, judges may be removed by concurrent vote of both houses. But the only way the members are going to know to impeach under Article 5, Section 1, or the only way they're going to know to remove under Article 6, Section 6, is if the members start receiving petitions of remonstrance from their citizens.
So, Mr. Hibner, please call the case.
John Anthony Gentry versus former Speaker of the House Glenn Casada et al.
Thank you, Mr. Hibner, and the floor is yours, Mr. Gentry. Yes, Mr. Gentry.
So, my name's John Gentry, and I represent the interests of all citizens of Tennessee, seeking mandamus to compel the General Assembly to hear and decide a remonstrance, aggrieving the government acting in violation of the state's constitution. The seal of the judiciary reads, let justice be served that the heavens may fall. And that's what this case is about, is restoring justice to all citizens of Tennessee. And justice is defined as the fair treatment of people. Citizens cannot have justice without fair and impartial courts, and we cannot have fair and impartial courts without judicial oversight and accountability. And citizens can also not have justice without the voice protected in the right to petition for redress of grievance by address or remonstrance, but that right is oppressed. The fact that I'm the first one since 1850 to exercise this right is evidence the right is oppressed. The conduct of the government thus far evidences that the government of the state of Tennessee is no longer Republican in character or form and has forsaken the Constitution that created government. I find it absurd that I have spent more than a year in court proceedings and thousands of dollars defending constitutionally protected rights and demanding that the false version of the Constitution be corrected. I have a right to petition government by address, and I sought to exercise that right by demanding oral argument in remonstrance. That right to petition by address does not mean I have a right to orally address an inanimate wall and be ignored. That is common sense. Since I have that right, then government has a duty to listen to my address. And moreover, they have a clear duty to read petitions at the table.
So Mr. Gentry, you interpret the phrase address or remonstrance in the Constitution. You interpret address to mean actually going and speaking before the assembled representatives in the House.
Absolutely, I do, Your Honor. The Tennessee Constitution says by address or remonstrance. An address is an oral presentation, just like an inaugural address or the Gettysburg Address. It is an oral presentation and it is right guaranteed to us. But the House Rule of Order 15 and Senate Rule of Order 22, petitions shall be received and read at the table. And the word shall creates a duty. And the appellees have failed to perform their duty, and courts have the power to order performance of duty. In reply brief, or the Office of Attorney General has wrongfully suggested to this honorable court to deny me due process by ignoring the questions I have presented to this court. I have presented 6 issues on appeal, and due process and justice require my questions be answered and that I be heard. Since my time is short, I ask the court to carefully consider the facts, the arguments, and the supporting authorities in my written briefs. But I'm going to run just briefly through the issues on appeal, starting with number 6. The trial court and defendants have suggested that the defendants don't have a duty to display the Tennessee Constitution on their website, and therefore the court does not have power to order to a correct version be displayed and presented to the public. That is failed logic. The chancellor, the defendants, opposing counsel, as well as this honorable court, all have sworn oaths to uphold the state constitution. That oath creates the highest duty, and knowingly holding out a false version of the Constitution is a violation of oath. And since they have a duty to support and uphold the Constitution, the courts have the power to order performance of duty, and the court should order that the false version be removed from their website or replaced with a correct version. Again, respectfully, it is absurd that I have to bring a cause of action against high-ranking state officials to correct the PDF version of the Constitution held out to the people. And according to this court's own opinion, that false version is a constructive fraud on the entire citizenry. And I cited that case in brief. And it was an abuse of discretion and error of the trial court to dismiss this case on that cause of action alone. I have issue number 4. I have properly challenged Supreme Court Rule 10b as a mockery of justice, where a judge accused of a crime decides his own innocence or guilt. And that rule deprived me of fair court, and I ask for the court's opinion on that matter. And I have also properly challenged House Rule 15 and Senate Rule 22 as oppressive of the right to petition by address. Those rules deprived me due process and oppressed my right to petition by address. And issue number 3, there is no doubt, pursuant to Article 1 of the Tennessee Constitution, that citizens have a right to reform government, and pursuant to Section 23, to petition for reform by address. The need for reform is obvious. We have an incredible problem with judges that are not adhering to the law. Some of them corrupt. This is admitted in Government Operations Committee in the legislative houses. And that problem is the result of judges holding prohibited second offices of trust in the Tennessee Board of Judicial Conduct in plain violation of Article 6, Section 7 of the Tennessee Constitution, as well as it usurps legislative power of judicial oversight. And when the government is acting in violation of its Constitution, it must be reformed. And government has a duty to hear and decide such a grievance. And it was an abuse of discretion and error of the court to dismiss this case when such right is oppressed by the government. A government alleged and evidenced to be in violation of the Constitution must hear and decide a grievance. It is not discretionary. Issue number 2 on the appeal, counsel for appellees tendered a fraudulent, counterfeit version of my petition of remonstrance, materially altering and replacing my words with their words and omitting 57 pages. I protested that conduct immediately or almost immediately. And my amended pleading does not moot that misconduct. It is the same to say that no crime is committed if a stolen car is returned to the owner. And of the thousands of citizens that I have informed of that misconduct, every citizen is appalled. Counsel for appellees repeatedly made the false statement that she filed a motion to dismiss in accordance with local rule, and made the further false statement that a motion to dismiss is not a dispositive motion. Such conduct is incompatible with the trust and confidence placed in her as a high-ranking state official, and it was error of the court to not sanction or in some manner apply punitive measures. Falsification of evidence without punitive measures creates chaos in our court, and it is the duty of every single judge to report attorney misconduct pursuant to Supreme Court Rule 10. Issue number one, there's no doubt that I was denied the procedural safeguard of not hearing a motion to dismiss, and it was also a motion for summary judgment in less than 30 days from the filing date. This plain violation of local court rule and Tennessee rules of procedure provided me only 3 days to respond to the motion to dismiss, and I was denied adequate time to respond and denied adequate time to prepare for hearing. And it was an error of the court to conduct a hearing of a motion to dismiss in plain violation of procedural law, and further error of the court to repeatedly deny me the opportunity to present complete argument in response to the motion to dismiss. And issue number five, soon after tendering my amended pleading, the court involuntarily dismissed the case, even while holding that the initial motion to dismiss was moot as a result of my pleading. So it could not have been possible that the motion to dismiss could have been granted. The case was dismissed in abuse of discretion and error as an involuntary dismissal. And it has been the opinion of this court, dismissal is a harsh sanction, not generally favored. And in Harris v. Baptist, the Supreme Court said involuntary dismissal may effectively deny the litigant's opportunity to be heard and to fully present facts and evidence. And in this matter, I didn't even have an opportunity to present opening statements. My case was just dismissed coming out of the gate under involuntary dismissal. Clearly, dismissal of this case was a denial of due process. Clearly, this was error, and clearly it was an abuse of discretion and a denial of justice.
Thank you, Mr. Gentry. We will hear from you on rebuttal. In the meantime, we'll hear from General Kleinfeld.
Good morning, Your Honors. Janet Kleinfelter with the Attorney General's Office. I'm here on behalf of the defendants. This is a case that was brought on a petition for a writ of mandamus. The writ of mandamus is, of course, a discretionary remedy that a trial court can grant, and it can only be issued when, one, the plaintiff's right to relief is clearly established, two, that the defendant has a clear duty to perform the act at issue, and three, that there is no other plain, adequate, and complete method or remedy of relief available. And the trial court found that plaintiff's petition or amended petition for writ of mandamus did not meet those three requirements. In particular, the trial court found that the petition for writ of mandamus did not establish or did not demonstrate on its face a clearly established right under Article 1, Section 23. Article 1, Section 23 says that citizens have the right in a peaceable manner to assemble together for their common good, to instruct their representatives, and to apply to those invested with the powers of government for redress of grievances or other proper purposes by address or remonstrance. Both the trial court and the Tennessee Supreme Court have found that the right that is identified in Article 1, Section 23 is the right to apply for redress of grievances, either by address or remonstrance. It does not guarantee the right or the method or the procedures by which such petitions are to be addressed by, quote, those invested with the powers of government. And that is what the petition was seeking and was arguing. is that the petitioner had the right to petition and have his petition actually be heard and acted upon by the General Assembly. And that is the relief that plaintiff or the petitioner was requesting for the trial court to order the General Assembly to act upon his petition of remonstrance.
So you're saying that the Constitution says he can apply, but it leaves to the legislature to decide what to do with it once he has submitted his remonstrance.
That is correct. That is how the trial court ruled. And I would note that the trial court specifically found that the evidence in the record, as alleged in petitioner's own petition, that the petitioner had fully exercised this right to apply to the legislature. That in addition to having his petition filed in both the House and the Senate, that he had met with approximately 50 different members of the General Assembly to discuss his petition, and that he had emailed a copy of his petition to every single member of the General Assembly, requesting that they review and read his petition. So the first element was not, the trial court found that the first element was not established, that there wasn't.
Did either house read it?
No,
the open.
So the petition alleges that it was announced, it was filed, and it was announced that the petition was available for any member who wanted to come and review it, but they did not actually read the petition from the floor of either the House or the Senate. The second element that has to be established for a writ of mandamus is that the petitioner has to demonstrate that there is a clear duty here. In this instance, it would mean that you have to demonstrate that the House and the Senate had a clear duty to actually read and act upon the petition. And as you've heard this morning, and as is reflected in the proceedings below, petitioners relying upon House Rule 15 and Senate Rule 22, their rules of order, to assert that establishes the clear duty, that they are required to read at the table and also to allow him to present the petition by address to a joint body of the House and the Senate. The problem with that is that Article 2, Section 12 of the Tennessee Constitution specifically says that each House may determine the rules of its proceedings. And this court held in Mayhew versus Wilder that this constitutional provision is an express textual commitment of authority, which specifically and exclusively authorizes the legislature to make, interpret, and enforce its own procedural rules. And therefore, it is without jurisdiction. In fact, it would be a violation of the separation of powers, but it would be without jurisdiction to order the General Assembly to comply with its own procedural rules. In addition, this court and the Supreme Court have specifically recognized that because this is discretionary, the legislature's decision how to hear and decide is entirely discretionary, that mandamus does not lie here. Mandamus is only authorized when it is a purely ministerial act, not a discretionary act. And in particular, mandamus will not lie to control a legislative duty. So given the fact that the petitioner was not able to establish either a clearly established right or a clear duty, the trial court appropriately dismissed the petition. And the fact that there was not a operative motion before the court does not mean that there was a denial of due process, because again, mandamus is a discretionary remedy that the trial court can order. And in this instance, the trial court, the defendants or respondents to a petition are not even required necessarily to file an answer, and particularly when the petition on its face fails to make a prima facie demonstration of the right to that relief. And that's exactly what happened here, is that the trial court reviewed the amended petition and found that on its face, it did not establish either that clearly established right under the Constitution or that clear duty on the part of the House and the Senate to act.
So it was dismissed sua sponte?
There was not an actual motion to dismiss pending before the court. There had been a motion to dismiss the original petition. The petitioner then filed an amended petition that asserted the same claims but raised a new claim concerning the typographical error that exists in the Constitution that is posted upon the General Assembly's website. But it did not change the claims with respect to the original petition seeking that writ of mandamus to order the General Assembly to hear his petition and to allow him to address the General Assembly in a joint session.
Has the typo been corrected?
To be honest with you, I have not gone and looked to see if it has been corrected. The trial court found that there was nothing in the Tennessee Constitution that established a duty upon the General Assembly to post a copy of the Constitution on its website in the first place. Nor did it find anything in state law that imposed a duty as well. And without such a duty, the trial court found that it didn't have the jurisdiction, again, to issue a writ of mandamus to the legislature to require it to either remove the version posted on its website or to post a corrected version.
Well, if you're going to post it, you ought to post it right, don't you think?
I would agree, Your Honor, that you ought to have a correct. I will note that it is actually the petitioner, when he originally filed his petition, did not have the correct language, and I'm actually the one that noticed that there was the error here. But again, that is not the
It's not the meat of the petition. I understand that.
Right.
I was just wondering if they had gone ahead and fixed it once it had been brought to their attention.
I have not gone and looked to see if it has been corrected. And again, I'm not even sure if the General Assembly controls the actual website. I suspect that it is someone within the Division of Legislative Administrative Services that actually controls the website. The last couple of issues I just very, very briefly want to address are concerning the challenge to Tennessee Supreme Court Rule 10b. We know, first of all, that wasn't raised at the appropriate time, but more importantly, that is a rule of the Tennessee Supreme Court, and the case law is very clear that only the Supreme Court can determine the validity of its rules. A trial court certainly doesn't have jurisdiction, and even this court does not have jurisdiction. That matter has to be presented to the Supreme Court by an original petition to the Supreme Court. And with respect to House and Senate rules, the challenge to those rules, that again was not appropriately raised. It was not raised in the petition or the amended petition. It was only raised for the first time in the Rule 59 motion to alter amend the trial court's ruling. And this court has recognized on numerous occasions that you don't raise new arguments in a motion to alter amend, particularly when these are arguments that could have been raised in the original proceeding before the court.
You observed earlier that the Constitution says the House and Senate are the judges of their own rules. Does that mean that this court has no jurisdiction to examine those rules for constitutionality anyway?
The court is not without jurisdiction to determine that the rules are in compliance with the Constitution. But again, this is an issue that was not raised before the trial court. It was only raised in response, in a motion to alter amend. And so if there is going to be a challenge to the rules, that challenge should have been appropriately raised in the trial court first for that determination. Otherwise, it was not appropriately before the trial court, and it's not appropriately before this court. The very last issue is with respect to the numerous arguments that are in the petitioner has raised with respect to these alleged procedural due process violations. Those all go towards the original petition for the writ of mandamus. And as I would note that the petitioner filed an amended petition which mooted out all of these particular claims and issues that were raised. So unless the court has further questions, we would respectfully ask the court to affirm the decision of the trial court.
Thank you, General. Mr. Gentry? Be sure to unmute.
Thank you. I just checked the General Assembly website. The Constitution is still incorrect. It has not been corrected on the General Assembly website yet. That cause of action alone that I added to my amended pleading should have been addressed in the trial court. They have a duty to not deceive the citizens with a false version of the Constitution. Opposing counsel says that I didn't establish my right. I was deceived through a constructive fraud, and I cited the opinion in this case that holding out a false document like that, where I didn't know that I had a right to address orally. I didn't know that I had that right. So I was deceived, through a constructive fraud to not know that I had a right to address the government.
You were deceived by the typographical error or whatever it is.
Absolutely. I was arguing in court that by address of remonstrance means they have to address it, and that's when Ms. Kleinfelter said no, it's by address or remonstrance. I'm like, oh, good. Now I know I've been deceived by my government to not know I have a right to address them. This right of petition arises out of the 12th century Magna Carta, and in the 1640s or 1640, the House of Commons determined that commoners have the right to prepare and present petitions. And I have shown you in my appellant's brief the House Journal from 1831, where members presented petitions. You have to be heard. That's essential to due process, is to be heard. Yes, the opposing counsel is correct that the General Assembly can make their own rules. Well, they did, and they've had those rules in place for many years. And Rule 15 and Rule 22 says that petitions shall be received and read at the table. So they have failed to perform that duty. So I clearly established a right. I clearly showed that they had a duty to this. An important part of why the founders put in there to petition by address or remonstrance is stated by the Supreme Court of the United States. Publicity is crucial to justice. That any Star Chamber dark court proceedings that occur out of public view leads society to question, whether justice was served in that case. And so it is essential that these petitions be read at the table. It is essential that if citizens have something worthy of addressing the body, that they address the body. It was a clear failure of duty. They have established House rules of order that say petitions shall be received and read at the table. And it would be the same thing as an ex post facto law to go back and change, what their rules are to deny me, from having my petition read at the table or allowing me to address. The constitutionality of any issue, and it's in this court rules, I believe I referenced it in my reply brief, the constitutionality of any statute or any rule can be raised at any time. And opposing counsel has provided no supporting authority to say that I can't raise these issues at any time. And, if we want to kick the can down the road, I'm happy to go do a remonstrance with the Tennessee Supreme Court and challenge Rule 10B and challenge the House Rules of Order. I'll do it as a memorial and remonstrance in the Tennessee Supreme Court. I am tenacious. I'm not going to give up on it. I think it's wrong. I think it oppresses the rights of the people. So, let's not kick the can down the road. Let's address the matter right now. What I'm trying to do here is play the middleman between government and the people. There is incredible unrest in this country, and there is incredible unrest at the tyranny and oppression by government of its citizens, and there is no relief valve. This right of petition is the relief valve, and we need to start doing it now. It is fundamental to our form of government. United States v. Cruikshank, 1876, the right to petition for redress of grievance is fundamental to government, Republican in character or form. And we have to restore that voice and restore justice to our people. Thank you.
Thank you, Mr. Gentry and General Kleinfelter, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 11 a.m.